Bem-vindos a Brasília, a capital que, por meio de suas linhas modernistas, traçou o futuro de um país de dimensões continentais e enfrentou o grande desafio de integrar norte, sul, leste e oeste no desenho de uma sociedade mais justa, democrática e igualitária. Bem-vindos ao Brasil. Ficção científica do passado, capital das águas, quadradinho, avião. Reconhecida por vários nomes, esta cidade criada para ser a morada de uma burocracia que se alternava no tempo, um não lugar, cedeu aos afetos e se transformou em lar nas mãos de seus habitantes e nas gerações que ali se desenvolveram. Gostaríamos de tê-los aqui conosco, compartilhando das belezas de nosso céu, de nossas águas, de nossa cultura, de nossa gastronomia e de nossa gente. Porém, os desafios trazidos pelo momento crítico que o nosso planeta enfrenta nos impedem de vivenciar esses momentos com vocês. Mas de uma coisa podemos ter certeza: se a pandemia de Covid-19 nos afasta fisicamente, ela também nos aproxima ao nos fazer relembrar de que os desafios que a humanidade enfrenta necessitam ser enfrentados conjuntamente, reconhecendo que todos nós compartilhamos de uma condição que nos faz humanos. Se por um lado não estamos juntos, por outro nunca estivemos mais próximos em nossas preocupações e necessidades. Vamos juntos avançar sobre os problemas globais que se impõem. Vamos juntos construir democracias melhores, mais transparentes, mais responsáveis e mais participativas. Sejam bem-vindos à Conferência Internacional de Comissários de Acesso à Informação 2021.
Olá, bem-vindos e bem-vindas.
Hello, welcome, ladies and gentlemen. I'm Christian Pirroni, and I'm here to be the moderator of the 7th edition of ICIC that are promoted by CGU. So it's one of the last reunion, and it's broadcasting in 3 languages: English, Spanish, and Portuguese, in several channels. So it's a pleasure to be here talking about these people that represent our region of Latin America. We are here with Valmir Gomes Dias, who is responsible for the 3rd appeal instance of freedom of information of the federal government of CGU. So please be very welcome. It's going to be very nice to hear everything you have to say. When today's theme is interplay between data protection and access to information. We also have Maria de Lourdes Morales, PhD of Political Science for the University of La Sabrine Paris III, and coordinator of the Network for Accountability and Civil Society Representative. Please be very welcome today. It's a pleasure to hear today your point of view, and it's very important for our discussion today. And we also have Maria Anabel Campos Dias, lawyer of the legal board of the Counselor of Transparency of Chile. Welcome. So it's going to be great hear you today. So what is the theme that we have on the round table today? We are talking about these big changes that are happening in the last years, about the data protection or personal data protection in this pandemic time. We have this feeling that our personal data are in other ways here. And we have another law that's very important. There is the access information law, and we have to know how the public sector gives to the information to population, what data are important, the comprehension of the the civil public, because we already said how these data are important. So to have more efficiency, we have to see this paradox between this data protection and access to information. So it's, as we're going to say, it's just like paradox. So we are going to see the point of view of our guests today, how they understand this theme, how we can deal, how we can interact between these two informations. In this sense, our dynamic today are going to be, first, we are going to have a general understanding and your considerations. And after that, we're going to have a debate about the hard points and the convergence points that we could have. So in this sense, I would like to invite one of our colleagues to start. So, Maria Anabel Campos Dias, please give your point of view about this interface of protection data. Thank you very much. Good morning. My name is, and I'm also a representative of the Supreme Court and the information law and the access of the information. I'm going to share what we have today about the curriculums that clear of the courts. We have some constitutional data, and in this process, we have to work together between the institutions and work together in an harmonic way. In this year, we had these ponderations. In some specific points, we have to work with transparency and this data relevation and the social control in a way that allows us to make these rights to work, and we have to verify together with all the other rights, because we have to protect this data and link it to the responsible people, because these rights that we have in the information law, these rights indicates that they are recognized in the institution. We have laws that working with that, and it came to get better the article in the law and all the principles, and that allows us to do the public service. And we have this constitution that allows all the rights to be guaranteed. So we are talking about the data protection, and this collaborates to protect all the information. We still don't have a date that will have the assurance that these data are going to be protected, but we have assurance that they're gonna be protected. In 2010, we have some laws that helped us to protect all data because it's a fundamental right and it favors that in our country. So we guaranteed the access information, and clearly in this part, we have a regulation, we have a unique access, and we are looking at the information protection. In a general way, what we have, in the law, we can say in a regular way, and this brings closer the functions and the transparency, and all the states are working, and we give emphasis because we have the right to access these public informations. We have some laws about that. We have to do the accountability, and we have to put the transparency as a culture in the public service. So we have to verify in the law, in the articles of the law, that we have the duty to work together with the Constitution. And it's very relevant to look the article in the law to do the right ways to protect data. And this article was put in the law as a transparency tool, and in this only on this article we could see how important to put that in the laws. So we have to understand that everybody should have access to the information. We have to guarantee that with this law, and we have to talk about that to specify in a better way which function will be that. We have to accomplish these goals, and we have to guarantee these informations. And another kinds of informations, we have to guarantee that these laws will not pass as something without control. And we have to regulate these procedures in accordance with the law, and we have to protect data and private data, and in a specific way we have to put in the accordance to law. And all of that has an amplitude. We have been working with that as an activity in a multiple relation and in the better way with all the parts. They're not an obligation. We can check if they are right. All this protection of these laws have been audited and in accordance with the law. And we have to work with the active transparency because it's a public information. We have this recommendation about protections of personal data. They are made by entities as a form to guide and regulate this personal data. And now I'm going to finish what are the challenges that are going to face related to this theme. How are you going to work with that? We have a lot of challenges facing these laws because we're talking about a country that are working with transparency. So we have to have all these in a constitutional way, mainly in the transparency part. So I believe that we have to understand how to develop in a inter-American and national way and guarantee the access to the information and personal data, because it couldn't be unbalanced. And it's relevant to the counselor, this protection in a constitutional way, and these have to be discussed here today in this seminar, in this webinar, because it's very new and it's a fundamental form for that to become practice and become real. So here in our country we have other legislative process, and we also know that we have an invitation of a new process. So we have to guarantee the protection of this data, this personal data. And we are going to work to create an independent part inside the economy to guarantee the transparency, and this is going to have a function as a public part to create how to develop that, because it's very recent, it's very new, this public function. So we are eliminating some articles and adapting how to do that to this process to be definitive. So we are going to create, together with the protection agency, and we have to work all together to get better in this contest. And we have an expectation how we can work with our rebuilding of the Constitution, and we have to develop this together. And we understand that we are facing security challenges, and we know that are some people that could be affected, and it's related to the sensible part of the, like the health ministry, the personal data information. And we know that to create the laws, and we have to spread and adequate this process to work, understanding that some people are going to be affected. And what we are doing now is to protect in the right way the information. We know that we have some personal data, but also people have the right to access personal information. So that is something that we have to say in a precise way, because we have to understand in the scope how we can protect this information. So we have to understand the path that has a role in this laws, in this regulation, which is very active, and we have guidelines in people's protections and the ponderation. In this case, we have to remember that
everything that is this controversy that we have of the right to access to public information and the exercise of this ponderation, this access to the resolution of this has to recognize these conflicts between the rights of access to information and the ponderation of protection of data, personal data. So we do this exercise of moderation to understand case by case. We have to verify this, considering that it's possible to associate the protection of people alongside the part of protection of the rights of these people, their difficulty, their privacy. So this exercise of ponderation has to be done case by case. This system needs to have a law, transparency law, this key team that will work in a regulated way. There is a principle that is recognized in this, the article of the principle of invisibility, which is within this power of legitimacy in the interest. And to know this work that we are going to work alongside this theme, putting this knowledge, public knowledge, alongside all this data which are associated to a person, determining that there is in the public interest that justifies this knowledge in this personal data. So we need to, having these tools through this, in particular, doing the Article 21, Article 2, device visibility. So with that, we have to understand this part to protect information that is solving alongside this, and then you have a relative part of these recommendations of principles so that we can work with the public power and do this defense alongside its resolution, our superior and the Superior Court of Justice. Thank you very much. I have a small point. Thank you. You can say something. I have an interest point about this talk about good practices, and would like to talk about this, about the principle of transparency, which is very proactive, and we have been developing this through the pandemic of 2019 presentations. We have regulated this matter of the COVID-19. We have been doing recommendations about transparency, considering the fulfillment of data, which are done alongside the authorities, working in this part of the alongside the data, and we're just asked for those who have 2 vaccine doses, they have this minimal data alongside the data required alongside the health bodies, which is justified for the event alongside these parts of information which be authored in this data. This is, I believe, I would like to talk about all this beginning of these works. Thank you very much. Very interesting that you said, because it brought a lot of these elements that you're going to discuss overall about the balance between transparency and data. Father, was very interesting. What you put there about the defense in the Constituent Assembly, in which you are living now in Chile, and this idea of having to put in the same pattern, in the same level, these 2 rights. It seems to be very interesting to be able to visualize this process of constitutional process to be aggregating in this sense. So it is already a good beginning for us to understand these complexities of equilibrium between both rights that are in both countries, particularly now with this vision of Chile. We'd like now to pass the floor to Dr. Lourdes Morales to make her first collocations, his speech in her 10 minutes, so that we can have this practical idea, this framework of thoughts. Thank you very much. Good morning to you all. And I thank the invitation. I hope my connection is good, because it was not so good before. Well, I am a member from the accounting, so I work alongside this project. in the body of transparency, and I also in the universities and also institutions, public institutions, like here alongside the Federation and social organizations that have dedicated their strengths to knowledge, fiscalization of other basic pillars of the transmission of accounts. I would like to take this moment, the intervention from Maria, from knowing this part of proximity of rights, of public rights here in Mexico, the revolution that we've been having from the right to know alongside the transport, alongside the public reform, political reform. We had a change in the Article 6, and we had the possibility to reestablish the right to guarantee information, the right that actually we felt we didn't have a way for the society to give this information. We had this the first way were just to mobilize citizens in the year 2001, where there was a proposal when we can change the order alongside the transparency body. This first federal law of access in public to public information was fundamental. And in this moment, we talked a lot about the right to intimacy, but it was already foreseen alongside the Constitution, but considerably we had the evolution, the rules in this law, because we have many sides. We started to create these regulatory institutions because we now have an issue, and then we created this institution, and we begin like this. And in Brazil, maybe you have mobilizations to ask, for example, to ask for the prison of the president due to corruption. Here we have a mobilization in Mexico to make a law to create. We see that in 2007 we have a constitutional reform, and in the first time where it is included not only in the base of articles, which is an important part, but also in the protection of personal data and the right of access to information. In 2014, after a procedure of watching the basis of the parliamentary open, we had a great constitutional reform that coordinates. There are three fundamental ideas. We had the federal law of data protection, the general law of actives, and the federal law to access to information. And then we had this story, this normative story, so that in a general way, there is these three laws. On one side, all states from the Republic and the Federation of Mexico have been working alongside these parameters. These parameters are maximum parameters, and in which these three laws communicated amongst themselves, and precisely to avoid contradictions or to avoid rights. So without this discussion, it happened in a way that was parliamentary. First of all, there was this discussion of the general law of transparency. There was a lot of participation from the citizens and had a lot of work, debates. In 2016, there was the approval of the general law of the personal acts, the personal data, with the participation of the population. And then we had in 2019 the discussion of the general law of articles. So then when we had all of these, we had parameters. We did not have this discussion, temporal discussion. We are completely articulating what we believed alongside the constitutional reform of 2014 in matter of transparency and access to information. So we had these contracts that we can see alongside these rights. We understand that the confection of these personal acts, access to information, they need to be guaranteed by a national law, in such a way that this reform that we have, this main exchange that was given alongside the national autonomy, and this create a regime of dysfunction that in a way that the exceptions will happen in a national level of transparency, when they have a contrary decision to what is established, the Constitution or the mandate, the term that we have here in the transparency law can give 0 points or can verify if there is this controversy. So it seems that this way, measured alongside this other action, it is through the exceptions, which are contemplated also in the rights of knowledge, alongside the protection of personal data and the right to intimacy. So the treaties, international treaties that you know very well, that you know the tutelage about privacy, the Universal of Human Rights, and from the public policies, the Commission of Human Rights. And then we have all of these alongside, against the right to know, alongside the Constitution in the first article, which recognizes the fundamental rights in the mark of protection and guarantees this. What has been happening was the exceptions. We have the exceptions, central exceptions, when we are talking about the rights of possibility to having a greater network of information for the access. And the oppositions or the exceptions, they are contemplated, if contemplated alongside the law, when these people that are asking for this ratification and the canceling are not being a titular or do not find themselves used in the personal data, or when there is an impediment, legal impediment, or a resolution for a competent activity. For example, in the last case, we have the idea of a person that asked for the cancellation of this information because it appeared in the internet. It appeared, for example, that it was the provider. So please take my data from that. I want to take that away because it was alongside the part of corruption. We have this reform that this could not be asked for, that we had been working on, the possibilities of participating alongside. So when we are doing this cancellation, it is when we cannot do this exception. So then we're going to talk about exceptions in the right to information. It is interesting how we can consider these rights, for example, when we are compromising the national right in the Mexican law that establishes the information, the confidential information that we cannot put the public life. The person needs to be reserved, and when this is a reserved information, we have other exceptions that you establish. One of these exceptions with just compromise national security, when we are going to lose, for example, negotiations or international relations, when there is information that, for example, involves policies, politics, to have risks to life, to the person's health, to things about things that get obstructed, for example. I'm not going to talk more about this, but some exceptions. This is the theme of national security that seems here in the case of American case that we are talking about. I do not know if we are in a normal way, but we have an example here. I do not want to more about this point, which is a Pegasus case. The Pegasus case that we can see, we have a case that began in 2017 when it was known the Mexican control of a software created by a Israeli enterprise which was working in less than 45 countries. It was a tool for remote access that has the capacity to do a hacking in telephones, the mobile phones, installs itself there, and then there is a text message and they click and they take this information. You are infected and they have access to all this person's communication. So in 2016, we had an organization alongside the civil society that was in the University of Toronto that published an information about this index, this thing that happened, this group, about this usage of defenders of human rights, about this tool which was being used for espionage, to espionage people considered as enemies of the government. So in 2017, the civil society worked and documented that many activists had been spied on with this device, and in the Mexican government we had announced about this act. And later the General Controller Office had the access to this, and then the Mexican government classified them when we're talking about this exception, saying that it was a risk to the national security. So we are seeing now a vulnerability of data, and this generates so that the social organizations can demand these institutions to make that are part of the alliance of the open government to that make a relation about this, because we knew that this would violate the confidence votes, let's say. So with that, in 2018 here in Mexico, we're going to see the head of this government, and then we can talk about the scandal that there was this pressure in the government. But I do not want to talk more about this due to the time. We had this study that was structured alongside this open government, and we had the exchange of this regime in 2018, where we have more information about the government, about these contracts. And this is one of the things that happen in life when we think about that this chapter had already been ended. It shows that thanks to these demands for access to information, that we had an investigation periodic organization done by Washington Post in El País, which give this event, this presidency of the Republic never canceled this authorization of the software. And that they're not happy with this. We had new contracts that were spying on us in these phones of activists without the necessity. So this was, with just one call, we could have taken this out. So everything that we can learn about this experience nowadays is that the government but it seems that there is no relation in that we have here the data of these contracts in the instances of the federal government as companies, spying companies alongside the federal police, the Secretariat of Contracts in the national system, and the system of the Service of General Protection. So we have four, not that the agency is not one of them, but we can find one that if there is in all these rights recognized alongside the Constitution, alongside the laws, and it is very easy to have this vulnerability when we are using relationships, these resources. It seems to me that in a context of high violence, of organized crime, like we have here in Mexico, there is a lack of guarantee, although that we have the law, despite having the law, we have a lot of vulnerability because we need to understand these rights of knowledge thanks to these investigations so that we can activate this social vigilance, this counterpoint, so that we can guarantee these rights because we already know the law, so that we can pass to the people that are violating these laws. So this first part I would like to pass to you. Thank you very much. Thank you. We are now having a vision that is very rich of how this interaction is given, this integration of these both rights. What you put there about this software Pegasus that were percussed in the entire world, there is a vision that about how they have this interface, because these adds forms, this talks about the importance of having a good equilibrium between these two rights. When you have the access to information in a way that is responsible and healthy, you have the possibility of citizenship, organized citizenship, and to be able to somehow visualize how their government is using of the different tools that are available there in this case, like you're saying about Pegasus, and how this can make the rights of the citizens vulnerable in different countries. So I think that is a great example to be explored, to be understood in a way that is more concrete. Now we are going to pass to Dr. Valmir Dias, talking about the point of view of Brazil. So please, I'm going to pass the floor to and then we have a few questions later. Well, good morning to you all. It is a pleasure to be here with you, you being the mediator, you are moderator with this emphasis on international regulation, and we have this technology, and to share in this panel of ICIC with Doctors Maria de Lourdes and Maria Anabel, which were presented. It's an honor to be able to share this space with you and share experiences and recognize the reality of other countries. When we talk about data protection and privacy, there is an international movement of decades in the sense of improving this normative. When there are distinctive models, so when each country ends up applying, using their making a modeling according to their reality. When this principle, this example that they gave, it's very important for us to share these experiences. And just taking in a part of your speech, and then from Lourdes, is that she said about this issue of treating the state, which is connected to the issue of privacy and the state action, which is confused with the origin of state. So when the state began to be there, there was this issue of dealing with these to pay tributes for propriety. So the series of issues that were amplifying alongside the time.
The name itself and the surname enter with the identity register that identifies the citizens. We have some needs, and it's always good to have in mind that a consistent legislation doesn't have to not have the state to act, but to comply the rights. When we speak about the fundamental rights in Brazil, we have discussing this law, general law for data protection, and besides its 2018, the majority of the articles are just happening by last year, when we have an approval of amend Pact 17 that brought constitutional the rights to privacy as a fundamental guarantee. But we can see in this article, in the 10th article of the 5 article that treats about the personal rights, like image, like protection of privacy. We can see that. So this PC, as it was published, it's going to guarantee a right that's already in the Constitution. So this theme is important, and there was this recent necessity to put what the Constitution says in our law. So we are going to talk about the interaction about privacy and the access to information, because it's a fundamental right that are in the Constitution, in the 33 article, that's all about all the rights, the collective interests. And so we have this doubt until where we can go in the personal information access. So this panel here in November, because in this month we have 10 years of the law, and in the next year we're going to have 10 years of it's how it in 10 years of its working. So talking about the general law for data protection, it has just 1 year. So we have an interesting math related to November. So it's important to discuss this subject. So we want to show how we can balance that between the federal government and personal data. And we have a lot of protection data laws. For example, we can quote Victor Schomburg that talks about the first generation rights, like databases, and then the second generation that tries to complete the first generation. And it shows it's more evident in the third generation because the main character starts to think about that. So it's consolidating the fourth generation and brings sensible data like shared data, like personal information and consentment. So we realized that Brazil went through this path. We have some norms about that. We can see, like in the 80s, our 88 Constitution brought the fundamental guarantee of that. So now we have a general law that puts together all these little subjects, like the 31 article. So we have an harmonization about the protection of data and the general law for data protection. So it's important to talk about with people from another countries, because here we have entities that are authority on that, like NPD, that works with this protection. And for example, we can see in the law that CGU is an appeal instance in the federal environment. And the law itself says about the necessity of the federal government say which body is going to be responsible to promote the campaigns to transparency, to the fundamental right to access to information training, and how we are going to apply in the federal environment. So CGU has this role in this federal government as a appeal instance and to guarantee this transparency in politics. So with that, we are facing this issue about LGPD and information access, because we still got some doubts. Like in 2020, when the majority of the articles start to put in action, we put in the platform, system platform, that is the channel to the citizens to make these rights good. So this platform in 2020, the second semester, in between August and December, we had 1,300 manifestations, for example, accessing their data or ombudsman. So with the subject of personal data and LGPD, we have 3,300 manifestations between all of them. So in 2020, until now, we have more than 6,500 manifestations. So you can see that the citizens are looking for to know their data. So it is searching their data. So it's important because the law itself brings some articles that indicates this compatibilization, and with that we have some doubts. For example, in the law, there are some articles that are public, so you have to considerate the good faith, the interesting. So from this seventh article, we can realize that some data are public. For example, how much public servant earns. We have the transparency portals. We have some people that receive pension, and it are on this platform. So we can see what are the guidelines in the LGBT that in this law we have this general information and how we can disclosure the public information and the social interesting. So we can see how can we harmonize the the how ethical it could how ethical we could do this. I'm not disclosure any data because I don't like him, not because I want, but because there are some commands that says what I have to do about that. So in these matters, it's important to say that our legislation are inspired in the European laws that started in 2018. It has LGBT has a chapter that's specific to the public powers, the fourth article. So people has a lot of doubt about that. Can I have concern about that or not? So we have some hypotheses of legal obligation. What is essential for the public policy? So it's very important to balance how we treat in the private initiative and the state. Because until LGBT, what we didn't have, it was in relation how we can treat the private and the public. So we are now studying which decisions are made in the public service that are regulated by the algorithm, and we have this difference between the private sector, and so the public service is still working with in artificial intelligence, but just not that much to decision making. So the 20 article is more applicable. It's a point of concern that use in a more intensive way of this process decision making. So we have to use that as a tool to assert the rights. So if you think about the generation of data protection, LGBT comes to integrate the fourth generation. And this fourth generation bring the tools to how we can act on that team to get this rights guarantee. So it's not just a thought. We put that in practice. So when we bring this balance to the LGBT, it's important to see that the LGBT, the information law already had the guarantee of the privacy, the protector for images. So the decisions, the delivery of information by this information, we couldn't see the impact on the LGBT because the public government already had the obligation to protect this kind of information. So LGBT is not just privacy, a secret law. It is a law that brought tools to the citizen to exercise their rights, and how the entities, public or private, have to treat this data, and brings a concept about the risk of how to treat this data. So we have a big question when we talk about information, that we have to know what the data that we have, the circle of life of this data. How are the records? Are these records um, virtual or physical? So the question of the access we are already had on the law. So that's important because sometimes we have some doubts and some entities are denying the information because of the LGPD, but there's not a conflict of the publicity of the information law and the LGPD. So it's very important to reinforce that, to avoid a mention to backspace, because it's a harmonization of the commands, because we talk about how we can do that. That generates more doubts. Um, we have to give transparency at a minimum required. But it already was a question that we have to watch, that we have to see. For example, in Mexico, we have this concept of the damage test. We are going to evaluate how the damage are going to affect the information, if you have to restrict or publish. So we have this understanding in Brazil related to decisions. For example, CGU, when the court judge the appeal instance, we have the law guiding that. So we have to balance the damage and the disponibility. So it's very aligned what Mexico is doing in this sense of understanding about treatment, and it's also applicable of personal data. So the proportionality of this treatment when we disclosure how much public serves earns, we do that as a social control. We're gonna not to disclose your personal data because it's something that's not need for the goal of the control, of that social control. So that what we have to have in mind, the proportionality, and the legislation already brings that. So we can have a second view on the law. So we have this information collect in a public way, in a public guideline that have a specific forecast, considering what the law already brought. So just the final thoughts of compatibility when you talk about Chapter 4, the Article 23 in third paragraph says about the deadlines and procedures, what the public government are going to watch on this disclosure, especially habeas data, general law, and the information law. So the LGPD brought what we can have to watch about deadlines. So what are the requests about information about personal data? So that's this general panorama about the idea that we shouldn't have a conflict between data protection and information access, because data protection, it was a constitutional theme, and the law just put the principle in their articles. So what we have is a need that the body has to bring to and know to respond the owner of the data, especially the Article 18, how they can change, how they can eliminate, or the Article 20 that has an automatization of the information. So I think that are more useful about the private enterprise. So that was my initial speech. I hope I can contribute with that. Thank you, Dr. Gia. It was a very rich initial thoughts, and all we want to comprehend in this day to day, trying to understand what are the good practices and good ways to balance these two rights in a way that transparency and data protection is be just and healthy in behalf of the public sector. So thank you very much. And I think you talked about that something very important, and is very interesting to mention countries like Brazil, Chile, and Mexico. That's the idea that our models like this that was said and shows in this region, and a lot of these practices converge in the sense of a balance, a pattern, a standard, in the idea that bodies exist and are present to make easier this balance. So it was a great initial talk. So to close this this beginning, I just want you to have final thoughts where you see that exists a challenge. But remember, 2 minutes to do that. So I thank you very much. I thank you, everybody. So let's change the order. So first, Lourdes Morales for the final 2 minutes. Thank you very much.
Thank you. 2 minutes that I believe you're going to have this in these cases about the existence of a normative mark. We have the existence of this normative mark about the advancement of these institutions that can guarantee the fundamental rights, so that all the main challenge in the issue about law, but an issue about practice and reconnaissance of these rights. I believe that in this case, the Mexican case, as it can be the Chilean case, also one of the absences of this, the right to intimacy, the right of knowledge, is the not knowing this right and not knowing the fight, so that we can guarantee that these institutions help to be this part that is one of the greatest challenges. And second, I would like to say here that, for example, in Chile, we have a procedure that is very interesting of taking here in our constitution. In case of Brazil and Mexico, we are in governments which are tendencies that are autocratic decisions with the limitation of these rights. And this is a challenge to make in a conscious way alongside the citizens, so that they do not lose that. And the last one, where the pandemic showed us the horrible inequalities in our countries, in our deficiencies of a state that has been working, that has not done in a way that the state should be doing. These rights need to be focused alongside the exercise of the fundamental rights and the more of the people that are poor. So we need to guarantee this. So then, talking about these rights, we need to take into consideration that the primordial idea of access to information is the population to be able to have a knowledge about what the state is giving. So having knowledge that you can have this right, it is a previous element in this sense. So then I'm going to call Dr. Mariana Belcampo to talk about the challenges that is still in this complementarity of rights. Well, I believe that we have so much in the interface for the access to information, but I would say that understanding we have an emphasis on the protection of people because we have this knowledge of this exercise. But at least with this issue of transparency, we have a little of familiarity with this that is included in electronic way in this transparency. So we need to put this together alongside this very work. But I believe that the exercise in a way that has been diminished because, for example, Maria Lourdes, we do not know because we have a law that we had to alongside this repetitive work with other people that are working alongside Article 1 and 12. And mainly, we need to understand that this norm, they need to work alongside this, and we have a precise way, but there should be a reinforcement throughout this exercise to the right of data protection of personal data that is alongside the right to access to information, and that needs to have an information alongside associated to these people which have effectively this because we have been connecting and that we have in a proportional way or to ends that meet that justify this. This is a challenge that we need to understand because it's a very complex way. This is a difficult thing to understand precisely. It is a function that brings this challenge forward and fundamentally our council in a future way, but in a facultative way. We can develop this to make this in ways that we can with campaigns, with relations alongside the conscience of people, and to guarantee these rights to personal data in a such as to reinforce alongside the pandemic that brought this in the governments. We understood that we have a fight to understand this, but I believe that the future authorities contemplate their maintenance, their planning to contain all of this because we are also in a financial crisis and the COVID brought a lot of damage, the lack of this exercise of these rights, they are very relevant. I believe that. Then I'm going to answer other questions. I thank for the invitation and thank you very much. I believe that there is also this institutional part to maintain the institutions alive, not only conscientize, make it conscious the population, but also then talk to them about the importance of these institutions. So effectively, it is a very interesting process to verify from the point of view of the region how these different institutions are for the enforcement and the effort that is in there. And thank you for what you said. And now we're going for Dr. Valmir Diaz for his last talk, talking about the challenges that appear in order to complement this. Well, about the challenge, I bring the experience that we have in the implementation of the law to access to information in Brazil, because that is very similar to the challenge in relation to the general law of data protection. In the first moment, there is a necessity of an educative action that's very strong, not only for the citizen that needs to know how to exercise their right, but also for the public bodies in relation to these compatibility, to this harmonization of the access to information with data protection. And we have a challenge that is very big here in Brazil because it's the issue of the Federative Pact itself. Now we have a national authority, for example, that contemplates all the bodies and powers sovereign initiatives. So we have more than 5,000 municipalities in our country, 26 states alongside the federal district, many federal bodies. So to have the adequate treatment, let's say, for the public database, it's a very difficult challenge for the manager nowadays. When the citizen asks for the access to the confirmation, for example, of this treatment, there is a great difficulty for the manager to be able to answer this information. So I think that a great challenge from the side of the public administration is to make an instrument or this, and the tools from the citizen, and the citizen needs to know their rights and how to exercise them. So that is why I see that the balance between the access to information and privacy, it's not in a conflict of norms, but in the capacity of the state to have this mapping of this information to answer to these demands. And also, obviously, the adequate use of information, because the Article 31 of the Law for Access to Information brought this right of the citizen to have access with some protections related to privacy, honor, to the image. I think that the greatest challenge is to map the life cycle of information nowadays due to the general law for data protection, and it's important to work in this so there is no leakage, the undue disponibilization of data, to guarantee this right to for they can have their privacy preserved. And within this sense, we have in the general law for data protection, the report for the impact of this data. It is very important that the bodies work with these reports to see which type of dealing of data treatment can implicate in this to guarantee fundamental guarantees of the citizen. So I think in general that are to synthesize this, we have a great path ahead, and the advancements that will be gradual, but certainly very important to aggregate for the public the state organization compatibilizing these for these guarantees of each citizen. Certainly. So we have many challenges. A challenge to know the citizen, to understand the public administration of the structuring and the importance of the institutions, public institution, and also we have a challenge of the public institution to organize themselves to be able to preserve the rights in a responsible way and healthy way. I think that here we saw a panorama and framework of the interface and interaction between these two rights. And then we saw many different models of connection between these two rights, the point of view from the region. And in this sense, I thank the presence of Dr. Maria Anabel Campo, Dr. Lourdes Morales, and from Valmir Diaz. And also I think the possibility of here as a researcher from the area to bring here the possibility to hear about this data in this moderation. So I thank you all who are hearing us in these different countries about these different bodies, which shows already a vision of coordination, of compatibility with the role that I thank for CGU for organizing this, and for us to be able to have this possibility of having this talk that was very amazing. So lastly, I make a demand so that we can continue these talks, be it from social network, emails, be it with new events with the same sense. So thank you very much and have a great day, you all. A great day to you all. Thank you. Have a great day. Thank you for the invitation.